My name's Ed Harris. I'm the Chief Communications Officer at Family Equality Council, and I'm happy to welcome you to today's webinar, an introduction to legal issues for LGBTQ families in Louisiana, to accompany our recently released Louisiana State Law Guide. So today we'll be talking about an introduction to legal issues for LGBTQ families, and we're here with our partners at Forum for Equality and with two attorneys who I'm going to hand things over to Shelby Day to introduce.
Hi, my name is Shelby Day. I'm Senior Policy Counsel at Family Equality Council, and I lead our state policy work throughout the United States. And with us today, we have two Louisiana attorneys, Brandon Robb and Andrea Rubin. They're both partners at the law firm of Delaney, Robb, and Rubin, attorneys at law in Metairie, Louisiana. Brandon has several years of practice experience in areas of estate planning and successions. He's a board member of Forum for Equality. And Andrea has substantial family law experience and is a governor on the Louisiana Human Rights Campaign Steering Committee and Federal Club co-chair. We are delighted to have both Brandon and Andrea and truly appreciate their contributions to the guide and to this webinar today. We also have Sarah Jane Guidry. She's Executive Director of Forum for Equality. She's been in that position for 7.5 years, and Forum for Equality is our statewide equality group partner, and they've partnered with us on this guide, and Sarah Jane is going to talk a little bit more about the work that they're doing there in Louisiana.
Hi, good morning. I'm Sarah Jane Guidry, Executive Director. I just really first wanted to start off and thank Brandon Robb and Andrea Rubin of Delaney, Robb, and Rubin for their hard work on this project and basically continuing to represent the LGBTQ families here in Louisiana. And also a really big sincere thanks to the Family Equality Council for spearheading this project and putting this together today. We very much appreciate it. So Forum for Equality is Louisiana's statewide human rights organization for the LGBTQ community. We work at the local and state level, and when needed, we are also in the courts. We've been working on behalf of the LGBTQ community since 1989. And in our almost 3 decades, we've fought many battles. Most recently, we've been very successful in killing bad legislation that's threatened marriage equality since the Obergefell decision. And we've been so successful in that actually last year we were the only southern state that had 0 bad bills filed in the 2017 session. Currently, we're also working to support Governor Edwards' executive order. So for those of you that are not familiar, Governor Edwards signed an executive order that protected state employees, state contractors, and recipients of state services from discrimination on the basis of sexual orientation and gender identity. Thereafter signing the executive order, our Attorney General, Jeff Landry, filed a lawsuit against the governor, and that's actually currently on appeal at the Louisiana Supreme Court. So we're continuing to work on this into 2018, and we're very excited about the resources that are being provided here today for LGBTQ Louisianans, because until we have full lived equality here in Louisiana and we're all able to live and love equally, we have to make sure that we're educated on the laws and rights that we are so afforded at this time. So again, I really want to thank the Family Equality Council and Brandon and Andrea with Delaney, Robb, and Rubin for working so hard on this resource. I know it's going to be a big benefit for those in our state. And if you have any questions about the Forum for Equality beyond this, you can always visit our website, which is forumforequality.org, or you can send me an email, which is sarahjane@forumforequality.org. We're always happy to hear from our Louisianans and see how we can help you further. So thank you all for being here today, and I'm looking forward to hearing what Brandon and Andrea and Shelby have to say.
Thanks so much, Sarah Jane. I want to start before we jump into the presentation just to give a little disclaimer. So neither this presentation nor the handbook that this is based on is meant to be legal advice. Rather, it's an overview of the current state of the law for LGBTQ families there in Louisiana. As probably everybody listening today knows, the law pertaining to LGBT people and families is changing quickly and dynamically. And so it's very important that you consult with an attorney who's an expert in LGBTQ family law, or contact Family Equality Counsel, Forum for Equality, or one of the other presenters to discuss the details of your particular situation and to make sure that the information that we've provided today and in the law guide is still accurate law. So with that, we'll go ahead and begin with a relationship recognition. So in 2004, the Louisiana legislature passed a state constitutional amendment that limited marriage between a man and a woman. And later on that year, 78% of Louisiana voters approved that law. In 2005, there was a constitutional challenge of that law, and the Louisiana Supreme Court upheld the constitutionality. But in 2013, after the U.S. Supreme Court decided its case in Windsor and struck down Section 3 of the Defense of Marriage Act, the constitutional amendment in Louisiana again was challenged in two different lawsuits, one in state court, one in federal court. It actually was upheld at the trial level in federal court and was found unconstitutional a few weeks later by the state court judge. And while both of those cases were pending on appeal, the U.S. Supreme Court issued its opinion in the Obergefell case, basically saying that same-sex couples had to be permitted to marry and afforded the same rights and benefits of marriage as different sex spouses. And so now we have marriage equality nationwide, and by July 6th of 2015, just days after the Obergefell opinion, all parishes were issuing marriage licenses to same-sex couples in Louisiana. So what does this mean? This means that married same-sex couples are entitled to all state and federal benefits that are attendant to marriage. So any state or federal benefits that are afforded to different sex couples who are married have to also be afforded to same-sex couples who marry as well. So with that, we're going to move on to family formation. And just to set that up before I hand it off to Andrea to talk about family formation and protection. As we all know, there are diverse family structures in the LGBT community. LGBT people create their families in different ways. Sometimes that's one of the partners having had a different sex relationship, previous relationship, and having a child who was born into that relationship, and then a same-sex couple later raising those children. It can be through adoption, assisted reproductive technology, so use of an egg donor, sperm donor, embryo donor, or through surrogacy. So with that, I'm going to hand it off to Andrea to get more in depth into this area.
Hi, so I think to start, we'll jump right into adoption, and that's a pretty common way that we see LGBT couples in Louisiana forming families. So the requirements in Louisiana are going to differ somewhat based on the kind of adoption that you're seeking, and depending on each particular case and family will also vary what your lawyer is gonna recommend as far as the type of adoption that you're going to do. But the basic ones that happen in Louisiana are step-parent adoptions, and then private adoptions, and private/state adoptions. So all potential adoptive parents in any kind of adoption in Louisiana are going to have to undergo a criminal background check. They're looking mostly for criminal convictions pertaining to child abuse of some sort, certain felonies. They also want to make sure that there aren't any current or open child protective services cases against the adoptive parent. And all adoptive parents will also have to undergo a home study by a licensed social worker. And how that happens will depend on what type of adoption you're entering into. So Step-parent adoptions, somebody from the state will do it. In private adoptions, you would hire a private social worker to do the home study and make a report to the state. So it all kind of varies based on what kind of adoption you're looking into. But also note that these requirements are true for same-sex and opposite-sex couples. So there is no variation in the law when it comes to LGBTQ as far as these requirements under the law. Next slide, please. Thank you. So just some basic statutory requirements. If you are adopting as a couple, you have to be legally married. That's the same for same-sex as well as opposite-sex couples. So you cannot adopt, two people can't adopt the same child unless they're married to each other. You have to be over the age of 18 to adopt, which makes kind of common sense rule there. And if there's a birth mother, the birth mother and the birth father have to consent to the adoption, unless, of course, the state has stepped in because of problems in the parent-child relationship and have actually terminated parental rights. But otherwise, you will have to get permission from the birth mother and the biological father. The types of adoptions that we have in Louisiana are private adoptions. Private adoptions are the kind where you think of a couple finds they get in touch with a young woman who's pregnant, and so they adopt that child without kind of going through like an adoption agency or something like that. It's just kind of done with attorneys. The public child welfare system, so that would be kind of a foster to adopt system where you're going through the state. You're actually going through the state to find children that have been identified by the state and where parental rights have been terminated, who are seeking homes. Second parent adoptions, we don't actually have second parent adoptions in Louisiana. At the end of the day, it doesn't really make a difference to our LGBT families, but second parent adoption is just not something that we have here, so just kind of skip that one. And then step parent adoptions are pretty typical here. Those happen mostly in cases with two women where one woman use a sperm donor and the other woman will go into court to do the step parent adoption. So we can get into that a little more on the next slide. With the assisted reproductive technology, it's just a fancy way of saying sperm donation, egg donation, embryo donation. So we recommend to any couple that's considering having a child in Louisiana, if at all possible, to use, if you're two women, to use an anonymous sperm donor. It makes the legal process significantly easier. If you use a known donor, it's not illegal, but you do have to get the consent of the father. And you will have to terminate parental rights in a legal action. So it makes it more expensive. You also, you don't have any guarantee that the father is actually going to comply and agree to terminate his parental rights. Important to note too that you can't contract with sperm or egg donors in Louisiana prior to the pregnancy or after. Those contracts are considered null and void. And that kind of goes into the surrogacy issues. We get a lot of questions from especially same-sex male couples about hiring a surrogate, and egg donations and things like that. You cannot use a surrogate in Louisiana in the way in which people, that you may see people doing in other states like California or something like that. We just don't have laws that protect surrogacy. It's not illegal per se, but there's no way to protect your legal rights to that child. In Louisiana, the birth mother is the birth mother, and that's pretty much the end of it. So if you are interested in surrogacy, I would highly recommend that you speak to an attorney who knows about it, so you can get a full, overview of what that might look like and what your options might be if that is something that you want to look, you're determined to do. I do understand why, but just make sure you talk to an attorney before you sign any surrogacy contracts, because they're not valid here and they can't be enforced. There's a really weird little surrogacy law that Louisiana passed earlier this year. It has zero impact on LGBTQ couples. So it's in there just as a frame of reference if you're kind of a law geek like me. I'm happy. You can shoot me an email and I'll send you the statute to look at, but we can really, it's just in there so people know that it exists. So family preservation and protection. This is an area that I think most people are most concerned about. You know, once I have the child, how do I make sure that, you know, this is our child? There's presumptions of parenthood, birth certificates, court orders, and then, of course, Social Security and passport issues. So we'll just kind of, again, as Shelby said earlier, just kind of try and give an overview of what these things look like. And again, I would say, you know, if you have any questions, any specific questions, just be sure to contact an attorney who can help you kind of eke out all the issues that may arise in one of these things. So starting with the presumption of parenthood, or the marital presumption, in Louisiana, this is the actual statute. This is the language of the statute. The husband of the mother is presumed to be the father of a child born during the marriage or within 300 days from the date of the termination of the marriage. There's a lot of legal, you know, tactics you can use. Mothers can disavow husbands, husbands can disavow children. It's all not that, I mean, it can be important depending on what your particular family looks like, but I think it's really important for our LGBTQ families to know that this is still the language that is in use. So the Louisiana legislature has not changed any of the language in our code articles from, you know, husband and wife. They have not changed them to spouse. And, you know, based on Brandon and I's talking to people who deal with the legislature on a pretty regular basis, there's not any great hope of that changing anytime soon. So it is likely that the language of Louisiana law is going to remain husband, wife, and LGBT inclusive language is not going to be added in the near future. So I'll get into the presumption of paternity a little bit deeper in a second, but just kind of an overview. Birth certificates, I know that this is a big issue for people. If you are LGBTQ, and you're married, there's certain issues you must meet, but for the most part, you should both be allowed to be put on the birth certificate. So for married women, where there's two women that are married, one of them gives birth to a child, both parents are listed on the birth certificate as parent one and parent two, and married men who go through some sort of adoption procedure, the birth certificate will be updated to show that both of those parents on the birth certificate. So if you do go through a step-parent adoption or a private adoption, the birth certificate can and will be reissued to show both parents on that birth certificate. And if you have problems, if you go to the hospital and the administrators at the hospital will not put both of you on the birth certificate, you know, for instance, if you're a married female couple and one of you is given birth, they don't have a choice. So if that happens to you, just know that you do have legal rights and that the hospital is in the wrong in that situation. So I would encourage you to reach out to an attorney in your area to make sure that gets cleared up. Vital Records will make sure that birth certificate is reissued with both parents on it. Okay, so this is a lesser-known Supreme Court case that came out on June 26th of this year. It's created some unease, I guess. I mean, it's good news, but we don't know what it actually means yet. So the court basically said that that same-sex parents have to be both put on the birth certificate. There was an issue in Arkansas where a married woman gave birth to a child that was born of a marriage, and they used an anonymous sperm donor, and the other mother was not put on the birth certificate, so they sued Arkansas, and it went up to the Supreme Court. And essentially what the interpretation is that when in Obergefell, when the Supreme Court said that LGBT couples, married couples, are entitled to all the rights and privileges of marriage, that includes being put on the birth certificate and being recognized, you know, this parental presumption, but they didn't specifically say that. So, you know, again, talk to an attorney about this. It will depend on your particular circumstance what their recommendation on this might be. This is a positive step in the right direction with the Supreme Court. They're just they went back to Obergefell and basically reconfirmed what they said in Obergefell, but there's still some gray zones. So I know that this is the next slide. I know is a really big issue. And
well, Andrea, if I could interject on Pavan, I have to say it's our interpretation that you know, one of the things with Pavan, it didn't go to oral argument the way, you know, most of the cases before the U.S. Supreme Court do. Basically the reason for that is the court, in, you know, an opinion where they're making a decision like this just on the briefs, they're saying we've already decided this issue. This issue was decided in Obergefell. We said same-sex couples are entitled to all the same rights and benefits as marriage. One example that Justice Kennedy gave in his opinion in Obergefell actually was the birth certificate example, and you know, that opinion talked about children. And so while we expect that we're going to continue to see the kind of pushback that the dissent in Pavan had flagged and that we're seeing across the country, where people are trying to whittle away at the rights of same-sex couples to be treated equally as married spouses, we actually believe, and our sister organizations across the country really believe, that Obergefell made clear that both parents have to be on the birth certificate, and same-sex couples have to be treated the same when we're talking about things like marital presumption and other issues. Now, that doesn't mean, I think as Andrea was, as you were alluding to, that doesn't mean that we're not going to see challenges at the state level, both in the courts and administratively, and we certainly want to hear if you're being told you won't be put on the birth certificate if you're a same-sex, you know, couple who's married. But we may continue to see pushback, but we think that Pavan made really clear that Obergefell said what it said and that that's what the court meant. So I just wanted to throw that in.
Yeah, absolutely. No, Shelby's spot on with that for sure. So in so this birth certificate issue becomes a bigger issue, and this is, you know, the slide is pretty broken down as clear as it can be. And this is a question that we get as practitioners on a regular basis. Why do I need to do the adoption if my name is already on the birth certificate? And, you know, a birth certificate does not have a judge's signature on it. It's just an administrative document, you know, issued by Vital Records from the state. So with those challenges Shelby was talking about, you know, we don't know what the potential challenges are going to look like. I think given the political state we're in right now, you know, the only way to 100% protect your parental rights to your child is to go through with an adoption. You know, and there is just no other way to do it. So I think if you have any concerns at all that your parental rights might be challenged, you know, I would highly recommend that you speak to an attorney about moving forward with an adoption if you don't have a biological relationship already with your child. And again, you know, the birth certificate does a lot. I think it makes people feel good, and I think that there's you know, it's nice to have your name on it. And this is, but again, without a court order, there's nothing that you can actually take and prove that you are in fact that parent. And this goes beyond just your day-to-day lives. You know, if you're traveling out of state, if you're traveling out of the country, you know, situations arise where you might need to have that adoption certificate signed by the judge. There is no legal question at all, in fact, that child's parent. So, and
if I could, oh, sorry.
No,
I just wanted to add with that, just to really hit home on what Andrea is saying. So the birth certificate is an administrative document. It does not create a parent-child relationship. It reflects that parental presumption that a child that's born into a married relationship is the child of both parents. It's based on the relationship between the spouses, not the relationship between the parent and child. A court order is a court order that must be given full faith and credit by any court across the United States, regardless of what state you are in. An adoption decree is a court order. So Family Equality Council and all of our national LGBT sister organizations strongly advise getting a confirmatory adoption, especially in the political environment that we're living in. I mean, even before the change in administration, we advised our families to get confirmatory adoptions. And, you know, I can't scream it from the mountaintops louder now that people really need to be doing this to protect their relationships with their children, to protect their children's rights vis-a-vis that parent-child relationship and both parents' rights as the parent of the child.
Yeah, absolutely. And so to kind of jump in a little bit further into that birth certificate and the adoption areas, step-parent adoptions are the most common adoption that we see with our LGBTQ clients. This is oftentimes because one parent is already established as a parent, either a biological parent or an adoptive parent. So just to run through it super quickly, in a step-parent adoption in Louisiana, one parent, you already have to be established as the biological or adoptive parent, and you must be married to the person applying for the step-parent adoption. So the parents have to be married, and one person in the couple has to already have a parental relationship established. The adoptive parent is going to, as we talked about before, is going to undergo a criminal background check. The state's going to want to do a home study. But I will tell you that overall in practice, a step-parent adoption is a pretty smooth process for the most part. It's a lot easier and less time-consuming than kind of the private adoptions where you have a lot of attorneys involved and terminating parental rights and things like that. For the most part in step-parent adoptions, it's a pretty clean process. And again, like I said, we use this type of adoption mostly in lesbian couples where one parent was impregnated with an anonymous sperm donor. We also do this with couples who adopted children prior to the Obergefell decision, where they just didn't have the option to both adopt the child. So one, in a same-sex male couple, one father may have adopted one of the, a child, and they've been living as a family for all intents and purposes, but just haven't been able to, formally, legally recognize that parental-child relationship. So we can do that in those situations as well. Remember, step-parent adoptions still require any other biological parent to have terminated parental rights. So if you have children from a previous opposite-sex relationship, that other person is still going to have to consent to the step-parent adoption, and or their rights are going to have to have been terminated by the court. So that's important to note, and it's, again, another reason why we do recommend, if at all possible, to use artificial means and anonymous donors and such, so that you don't have to worry about that kind of third parent out there. And then lastly, just a quick overview. This is important, just for family planning, Social Security, passports, and those children. It's really important to make sure that both of the parents get registered, for the child at the Social Security office. The Social Security website does a good job of kind of giving you an overview of what they need to be able to do that. There's the website right there, directs you to that document if you want to look into that a little bit further. And it just kind of ensures that your child will be eligible for survivor or disability benefits from both of their parents in the event that something happens to their parents. This is the same for passports. You want both of your names listed on the passport as the parents. And again, there's a document website there to direct you to that document. If you have any questions about any of this, again, as Shelby has said at the beginning, please reach out to an attorney or somebody in the field who can kind of look at your particular circumstances and make a recommendation on what might be best for you and your family.
Great. I think now we're going to turn it over to Brandon to talk some about estates and estate planning.
Yeah, okay. So hi there. I'm glad to be a panelist on this presentation too, and I hope it's a really useful resource for our families in the LGBTQ community here in Louisiana. And again, I just want to kind of not to sort of repeat the same thing that's already been said, but just emphasize that this, all of this information is really good overview to have, but it's super important to contact an attorney to get particular advice that's tailored to your sort of unique family circumstances, which I know, no two families are exactly the same. There are going to be issues that come up for one family or one set of parents that aren't necessarily going to apply to somebody else. So, but just to kind of get into the estate planning stuff a little bit, and I know when a lot of people hear estate planning, they immediately think to themselves, well, I don't really have anything. Is estate planning something for rich people to do, to plan what's going on with their money? And that's really not the case. It's an important thing for every family to do, regardless of whether you're wealthy, middle class, working class, what have you, because everybody has some amount of property, and you want to really make sure that you're kind of like dealing with this in the correct way. So I'll just sort of walk through, I wanted to kind of walk through a few of the different considerations and documents that we always recommend that people have done. I know, we've talked so far about how families are formed and how, children and parents can protect their legal relationship to their children, but even once all that stuff is done, then it's good to get into this next part of planning for the future of your family. And so we'll just kind of start with, as you can see on this slide, there's a sort of a list of different documents, and I'm going to go a little bit out of order going through them because I think I'll just kind of go by. I'll start with the fourth one down where it says a will or pour over will with a trust. And a will is kind of the thing that most people think of as like the sort of penultimate important document that you need for estate planning. And people think of it as, and they're right, it's a document whereby people can outline and provide, stipulate what happens to many of their assets upon their death, and they can designate their heirs or legatees and provide for some inheritance rights for their children or their spouse, or for maybe even other people too. They can also make sort of particular bequests in there if they want to leave a particular sum of money to a charitable organization or a nonprofit that they really like. I mean, that's possible to do too. But basically, a will is very important, and it's important for every couple. Even couples that are married, it's important because, again, can sometimes be an assumption out there, and I've heard people say this, that, well, I'm married, so I don't really need a will because everything is just automatically going to go to my spouse anyway if I pass away, and that's really not correct. Louisiana, if you're familiar with what's called community property, Louisiana is a community property state. So spouses do have some automatic rights under the law to certain assets or portions of their spouse's estate, but it is also possible for married couples to still have separate property, which is treated differently under the law than community property. So if you died without a will, it wouldn't necessarily all go to your spouse, particularly if you have children or other surviving relatives. But a will can ensure that everything goes the way that you want to do it. And what's typical of, for married couples who have children is, especially if they're minor children or very young, what married couples often will do is provide for what's called a usufruct to their spouse, which is basically in other states is referred to as a life estate sometimes. And what that is it means that the surviving spouse will be able to have the use of all of that property for the rest of their lives. They'll have the ability to sell a home if they need to, or it's not restricted really in any way. But then the will also provide that what's called the naked ownership of the property. I mean, Louisiana has all these fancy, interesting terms for things. Will ultimately go to the surviving children when the second spouse passes away. And one thing that's really important that you can include in a will is what's called a testamentary trust. There are different kinds of trusts. Sometimes people set up trusts that go into existence during their lifetimes and can move assets into them. But another very common tool that we use all the time for clients is a testamentary trust, which is a trust that's included in your will, and the trust doesn't come into existence until you pass away, and then certain assets that you leave when you die are put into this trust, and they're held in trust for children who might be minors at the time of your death, and you can designate somebody, a trusted family member or a professional that you like, to be the trustee and kind of hold those assets on behalf of your children and preserve them. And then, the trust language will provide for when the trust can kind of terminate and that child can get property, can receive it outright in full ownership. And oftentimes we use a sort of a placeholder age for that, like 21 or 25. And then if you have really young children, sometimes it can be, it's hard to tell, or impossible really to tell, how responsible or not responsible they might be when they're around that age. So you can always, down the road, when you get a better sense of your child's maturity and responsibility level as they get older, you can always change the will language to adjust that age up or down, depending on the circumstance. But so wills are very important to direct how, just generally are important to direct how your assets are going to be distributed upon your death. Now, there are certain other assets, for example, like proceeds from a 401k or a life insurance policy, an IRA, certain other things that are not governed by a will. So with those sorts of assets, that you complete a beneficiary designation, and whoever you've designated as the beneficiary of those funds, that it will just be paid directly, with respect to life insurance, for example, the insurance company will make that payout just directly to that person instead of it having to go through, your will or be part of your succession after you pass away. So there's a little bit of a distinction there, but wills are really important, and they're really important for everybody. I can't emphasize this enough. Regardless of how little or how much you think that you have, it's really important to at least meet with an attorney and kind of talk about your circumstances, let them know, and they'll know what questions to ask you to kind of elicit all of the information that we would need to give you good advice and make some good recommendations and suggestions to you. Another really important thing that you can do with a will, and again, this is something that I always recommend to parents who have minor children, regardless of whether or not they, even parents who, an opposite sex couple who have children that there's no question that they're both the biological parents and they have a full legal relationship with their kids, it's always important to a provision for guardianship. And in Louisiana it's called tutorship, because again, here in Louisiana we have to invent our own language for everything. We don't like using the terms that everybody else does. So, but it's important. So you can designate, you want to make sure to confirm your surviving spouse's right to be the guardian of your children, and then you can also provide an alternate provision. So, for example, if something happens to both parents simultaneously, mom and dad, or mom and mom, or dad and dad are in a car accident together, and unfortunately neither of them makes it, and the kids are still around, who would you want to be, charged with being the guardian of your children? And oftentimes it's grandparents or aunts and uncles or a really close friend, but it's really important to kind of have that, document in, that in your document, in the will. So the will's where we would generally include that kind of stuff. And that's kind of that's sort of the overall broad view of a will, but again, it's really going to depend on specific circumstances, so always make sure you kind of talk it through with an attorney. The next thing that I'll talk about a bit is a financial power of attorney, which here is called a general procuration. And this is basically a document that allows you to designate your spouse or somebody else to be able to manage sort of your affairs financially if you're incapacitated for some reason. So if if you are if you're in an accident and are not able to communicate or care for your own, like take care of your own financial situation, like even just basic stuff like paying bills that come due and things like that, you're giving to somebody else, typically your spouse, obviously, or maybe, and then designate alternates for, like if you have adult children or other people, but somebody who will be able to have the authority to kind of act on your behalf, go to the bank, make deposits and withdrawals as necessary, and conduct transactions on your behalf while you're, until you are once again able to, manage your own affairs again, you recover from whatever has you incapacitated at the moment. And those sorts of financial powers of attorney can also last even if what has you incapacitated is not something that you might recover from. So if you are in an accident and you become basically, you suffer some sort of traumatic brain injury and are unable to thereafter care for yourself or manage your own affairs, that very well might last for a lifetime sometimes. So you want to have these documents in place that your whoever you've designated is able to continue to kind of manage your affairs for as long as they need to. The same thing also with a medical power of attorney, and that actually I don't see that it made it into the slide, but basically it's the same kind of concept as the general procuration, only except for with in the it doesn't apply to financial stuff. It's medical decisions. So if you're in an accident and you can't communicate with doctors on your own behalf, you're designating a spouse or somebody else to make decisions for you. Like they can communicate with your doctors, and your doctors will listen to and respect their choices. So if there's a decision that needs to be made about, well, the doctor says the options are, we can do this operation, or we can wait and try to resolve it medically, and there's a decision that has to be made, you're placing that that ability and that choice with somebody else. Now, spouses, under the law, have the automatic right to sort of make those decisions in the absence of a medical power of attorney. But it's also a good idea, just like with the financial power of attorney, to put an alternate in there in case something happens again to both people at the same time, or for whatever reason your spouse is unable to act. Or sometimes people even just have, they're married but they have maybe an adult child who is a medical doctor or a nurse, and they feel comfortable. More comfortable letting that person sort of make medical decisions, which kind of, it makes sense if you think about it. But again, it really is going to be very fact-specific, and it depends on your family dynamic. So again, another good thing to kind of go over with a lawyer. And then as a sort of an accompanying document to a medical power of attorney, there's also an advanced medical directive, which is also called a living will, which can be a little confusing because people can think like a living will is the same thing as a will, and it's not. It's a different document. And what the medical directive or advanced medical directive does is it really only comes into play in a situation in which you are because of some accident or other medical problem, you've been like 2 or more physicians have essentially certified that you are irreversibly brain dead. You're basically in a coma, and you're not ever going to come out of it, and doctors have sort of determined that there's no hope of you being able to emerge from that. That document is an instruction that you've left for your physicians that you don't want to be artificially kept alive under those circumstances. So that's the document that some people also like to have done, just so that there's not any ambiguity about what your wishes are in a situation like that. We'll go down the list here now to a jointly titled real estate, vehicles, and accounts down there toward the bottom, second to last one. There are in some states that do not include Louisiana, if you're jointly titled in real estate or vehicles or some accounts, you have automatic rights of survivorship, and so those things can sort of automatically, the title would go to surviving spouse. That's not the case in Louisiana. We have co-ownership in division here, so your names can both still be on title to a house, for example, or a vehicle, but you need to provide specifically in a will or in some other, in a testament of some kind that you want your spouse to receive your portion of that property upon death. So it's another reason why will is very important here. Hospital recognition, what do couples need to know? Does it make a difference if you're married versus unmarried? It does. If you're married, again, you're going to have, you'll be able to get certain information about your spouse's health and make decisions as necessary. If you're unmarried and you have not done any sort of medical power of attorney and you don't have any of that documentation, it's essentially as if you have no, the law considers you basically strangers, and so you don't have a right to, you don't have any right to make decisions on your partner's behalf if you haven't done one of these documents, which is why it's so critically important for everybody, but in particular for unmarried couples. And then also right in the middle there, where it says Varial Designation, that's a document that you can do if you want to, you can name your spouse or somebody else to have the ability to make sort of your final arrangements following your death. So you can, and those can be very generic. You can just say, I'm leaving to my spouse or to my partner the authority to make all of these choices, and leave it generic. Other people like to get very specific and include their wishes with respect to things like burial versus cremation or other stuff along those lines. So that you can include that in that burial designation document too. So that, I think, covers the estate planning portion of it.
And Brandon, if I could just add one thing. So, I mean, Brandon said, and I totally agree, I mean, this stuff is important for any couple, same-sex or different sex. I think it's especially important for same-sex couples because we're more likely to encounter discrimination. But, I think, in addition to all the reasons that Brandon said that are important to do these documents, it can be a real gift to your family in your end of life and passing if your wishes are spelled out. It's a difficult time when anyone's passing, when a beloved friend or family member is passing, or spouse, and once they've passed. And the more specific you are about what you want, both in the designation of your property and things like guardianship, as well as your final wishes, it just leaves less of a burden and less responsibility on your family to try to figure that out, or if people disagree, to try to come to some sort of agreement. So from a practical perspective, it also is really important.
Yeah, I think that's absolutely true, and I'm glad you emphasized that, because I mean it is not at all uncommon, and I've seen this all the time in my practice, is that families, even when everybody assumes, everyone has a good relationship with somebody, with their family members, like, they think everything's fine during lifetime, but then when, if mom or dad gets sick and passes away, then, once, it's, as you said, it's a very emotionally heated time for people. Things that, disagreements and other things that nobody maybe thought was there or were really below the surface can kind of bubble up during those times, and those fights can be very nasty sometimes and heated and emotional. And so by doing these documents in advance and sort of being very specific and thorough about what your wishes are, it can help your survivors a lot to kind of clear some of that stuff up and maybe avoid a little bit of it. So that's a really good, I'm glad that, Shelby, that you underscored that. Okay, so I think next up is I'll talk a little bit about gender and name change stuff. And so, okay, so it's possible in Louisiana to have your name changed if you want, and many people want to do this for a variety of reasons, and same-sex couples often do, even if they, if you're unmarried and want to use your partner's last name, you would go through this process to do it. Now, if you get married, if you're married, then under the law, you don't have to get a court order to use your married name. Any spouse in a marriage can use their spouse's last name under the law, and really all you need to do is present your marriage certificate to, if you're getting the name changed on a driver's license or a passport, you just bring the marriage certificate to those offices and get them to to alter the documents, and they'll do that just fine. So you don't have to get a court order to use your spouse's last name. But in other circumstances, if you want to change your name, you do have to, and it's really very easy to do. Actually, you just file a petition in court in the parish that you live in, and it's a very short statement that you say, you have to provide certain information like your current name and some other identifying information, and you just put in the petition, you're asking the judge, you want the petitioner wants to change his name to, and then you put what you would like your new name to be, and you have to include a statement of why you want to do it, but it doesn't have to. Your answer, and it often is just very generic. You can just put for personal preference. You don't have to explain why. You don't have to explain why that's your personal preference. You don't have to tell them anything about why you're doing it, but you just kind of make a little short statement about it's just my personal preference to use this new name. And what they do is, when you file this petition in court, the district attorney of the parish where you live gets served with a copy of it, and what they do, they're required to file an answer to it saying, yeah, we think it's fine for this person to have their name changed or not. But the only reason, because what they do is the DA will look into and see if there are any pending like criminal warrants out for your arrest or charges pending against you or something like that. As long as there aren't, then they'll tell the court, yeah, we have no objection to this name change happening. But you cannot use a name change to sort of like avoid criminal prosecution. So if you're trying to change your name to like dodge an arrest warrant, that's not going to work out. But in any other kind of circumstance, it's really easy and straightforward to do, and it doesn't take all that much time. I mean, usually if you file one of these name changes, there'll be a final court order signed within like 3 or 4 weeks. It doesn't take all that long for them to do their background checks. For gender marker changes, and is a special consideration for the trans community, people who are transitioning to their actual self-identified gender. It is more difficult and much more onerous in Louisiana to get a gender marker change than it is to get a name change. And there's all sorts of requirements for it that if you consult with an attorney, they can go over with you in detail. But essentially, anyone who is trying to get their gender marker changed on their birth certificate has to provide all sorts of medical evidence to the state that they've basically fully completed transition, including the way the statute is worded is that the anatomical structure of the person has been completely changed, which means that you've gone through all of the therapies and hormone treatments beforehand, and you've also had all of the surgery has been completed, so that your transition is 100% done. This is obviously very disadvantageous for a lot of people, because there are certain people who for which like getting going through the full transition process can be cost prohibitive for a lot of people, or for just personal preferences, they don't want to necessarily go through with the full operation. So it really puts those people at a very unfair disadvantage. Hopefully that will change in the future. Given the culture here in Louisiana, I don't know that it's going to happen anytime soon. But as the understanding of all this evolves and people become more accepting of it, it could at some point. But and also historically, in years past, this medical evidence that the state was requiring, they would put up some roadblocks to it. So for example, if somebody had gone out of state to have their final operation and surgery, or indeed if they lived in another state when they had it and then like moved back to Louisiana where they were born, the evidence oftentimes would have to be, the state would demand that the doctor or the surgeon who performed that operation give in-person testimony. And so if the doctor practices out of state somewhere, they were not even, the state of Louisiana, the office that does these things wouldn't even allow for like a video deposition or remote things like that. They were requiring that the physician actually fly to Louisiana and offer testimony. And of course, you can imagine how much of a pain that was for some couples. They've gotten a lot better about that, but the actual like threshold of proof that they need is still pretty. You have to establish somehow that you've basically completed transition. So that's needless to say, it's a lot more difficult for a person to get their gender marker changed than it is to have their name changed. So that's kind of the broad overview on that. But again, just with everything else, talk to a lawyer if this is a situation you find yourself in, and get their advice based on your particular situation.
Thanks, Brandon. And I'm going to be really quick in our last 5 minutes to just go through an overview of the non-discrimination protections and schools and hate crimes. The guide itself has more information and goes much more into depth, but I just want to give kind of in broad brushstroke the big picture. So there are no express state or federal protections for LGBT people in employment, housing, or public accommodations. In Louisiana, there are some localities such as New Orleans and Shreveport that have enacted non-discrimination protections, but these protections are relatively limited in scope, so it is important to know if you're living in those localities or wherever you live to know whether or not there are protections that exist. As Sarah Jane said earlier, in 2016, Governor Edwards did sign an executive order that prohibits sexual orientation and gender identity-based discrimination against state employees, and in some cases, contractors, employees of companies who contract with the state. It also prohibits discrimination based on sexual orientation or gender identity in the provision of services by state agencies, offices, and entities. The existing federal civil rights laws have been interpreted to provide some limited protections in housing, employment, education, and healthcare, but LGBT people remain especially vulnerable because of the lack of express non-discrimination protections. The only other thing I would add there is that oftentimes companies have employment policies, non-discrimination policies in their handbook, especially bigger companies, so it's also always important to know what protections that your employer provides to you. Moving on really quickly to school, Louisiana does have a blanket prohibition on school bullying. They require that all elementary and secondary schools adopt and enforce a policy prohibiting the bullying of one student by another. However, there are not express protections for LGBT students or prohibitions against sexual orientation or gender identity-based discrimination or bullying in schools. There is Don't Say Gay school regulation that's still on the books that originates back from 1993. And what this regulation does is forbid teachers from discussing LGBTQ issues. And unfortunately, this also includes sexual health and HIV/AIDS related awareness in the classroom. So this is a particularly onerous regulation that is there in Louisiana that we feel is harmful to all students, but especially LGBT students. Local school boards and localities may have non-discrimination and anti-bullying policies, so it's very important for you to know what protections and policies exist for your children in their local school boards and districts. And then under federal law, Title IX of the United States Education Amendments of 1972 has been interpreted by some federal courts to, at least one federal court, to prohibit discrimination against transgender students, and we feel that there are protections generally under the Title IX for all LGBT students. Finally, hate crimes. Louisiana's hate crimes law does provide a criminal penalty enhancement that includes bias-motivated crimes based on sexual orientation, amongst other categories or classes. It does not expressly include hate crimes that are motivated by bias based on gender identity or expression, but that criminal penalty enhancement is there. And then there are federal protections. In 2009, the Matthew Shepard and James Byrd Jr. Hate Crimes Prevention Act expanded federal hate crimes to the LGBT community, the LGBT people. And so again, I know I went through all of that really quickly, so I would encourage you to look at the handbook and read more in depth about those protections, especially the non-discrimination protections, because the guide goes much more into depth. And with that, I'll turn it over to Ed.
Thank you, Shelby, and thank you to everybody who tuned in and listened today. We'll be posting this recording on Family Equality Council's YouTube channel, so you'll be able to find the recording there, and you'll see on a link here, and also along with the recording, we'll post a link to download a PDF copy of the guide that you see on the screen there in front of you. And as Shelby said, we encourage you to reach out to either the Family Equality Council or to either Brandon or Andrea, whose email addresses you see on screen right now. And if you have any questions, we'll be happy to try and answer those and point you in the right direction. Thank you to Brandon and Andrea and Sarah Jane for joining us today. And I think that concludes our webinar. Thanks, everyone.